The Sarasota County Bar Association is a proud partner in bringing you law in Sarasota. With voluntary membership of over 1,000 lawyers and judges, the Sarasota County Bar Association serves its members and your community by advancing legal professionalism, promoting practice development, and fostering fellowship. Visit www.sarasotabar.com for more information and to use the online directory to find an attorney.
This program is brought to you by a grant from the Community Foundation of Sarasota County and the Sarasota County Bar Association. The Education Channel produces the program and broadcasts from its state-of-the-art campus on Beneva Road. They make this program possible.
Welcome to Law in Sarasota. My name is Andrea McHugh, and I'm a circuit judge serving on the bench here in Sarasota since 2017. Currently, I am assigned to the Juvenile and Dependency Division. For today's program, I have invited Magistrate Deborah Bailey, who has served as a civil magistrate or a hearing officer for the 12th Circuit since 2005. General magistrates are widely utilized in the Florida court system to assist the judiciary in effective and timely resolution of cases. They are appointed by the chief judge to hear cases and make findings of fact and recommendations in general magistrate reports to the judges in family, circuit civil, unified children's court, and the probate divisions. Once the general magistrate has filed a report with the sitting judge, either party in the case may appeal using exceptions to the general magistrate's findings and recommendations. If there are no exceptions filed to the report, the judge generally will enter an order approving of the decision of the general magistrate. Magistrate Bailey is highly respected amongst her civil litigators, and she's highly respected for knowing the law, handling cases efficiently, and writing thorough orders. She's also highly respected amongst her colleagues, the judges, who in the civil division have benefited for many years from her good work. Sadly, she is retiring. In this episode, Magistrate Bailey will look back at her incredible career and also share some advice from the things that she's learned for her many years on the bench. With that, I would like to welcome Magistrate Deborah Bailey to today's interview. And I will just start by telling the audience that as we sit here, right here this afternoon, that you came directly from your office for the last time, turned in your keys, and this is officially your first moment in retirement. So how does it feel?
It feels exciting. It feels strange. I don't think I've fully digested it yet, but I'm looking forward to retirement. And it's just been a whirlwind type of day today, actually.
I bet it has. So I appreciate you sitting down with us. I know there are so many people in this Sarasota legal community that really appreciate your work and you as a part of this community. And so they'll be interested to hear your thoughts and reflections today. And we're just very grateful for your time.
Thank you for having me.
Yes. All right, so first I will start out from the beginning, and I just want to know what made you want to become a civil magistrate, and what was your background, and what sort of prompted you to apply for the position?
Well, my background is in public health education. That's what my undergraduate degree is in. But I got a paralegal certificate, then moved on to law school, and started working for the circuit as a trial court staff attorney in 2000. And a civil magistrate position was created in Sarasota in 2004, late 2004. And I had been working for the circuit at that point for almost 4 years, and everybody was like, why don't you give it a shot? So I did, and got chosen. And my background has mainly as a lawyer was in plaintiff's work, although I did some bankruptcy work as well. Had not worked for any defense firms, but I was an unknown quantity in Sarasota as far as the local bar was concerned, because I had just been a staff attorney for the court from 2000 to 2004. So that was a little bit of a challenge coming into the magistrate position. So.
What was it like taking the bench for the first time in those circumstances?
The first word that comes to mind is scary. The first day I walked into courtroom 5A at the Silvertooth Center, I was rather nervous, to say the least. And you walk into a room full of attorneys and you're like, they're all here to see me, and they're here to hear me rule on their cases. And it's kind of heady, but it's also scary at the same time. You hope you're prepared. You hope you're prepared well enough. You hope that you're not going to trip over your words all day. And you hope that you make decisions that are based in the law and based on what facts and whatever other authorities that they're giving you. So it was scary, but once you got through the first day, it became progressively more comfortable to go into the courtroom each day.
All right. Well, can you give the audience an idea of the types of cases that you would handle and what you would be doing?
Well, primarily the magistrate position in Sarasota was to handle discovery motions and motions directed to pleadings, primarily non-dispositive motions, motions to dismiss, motions to strike, that type of thing. In last couple of years, I've also started to hear a lot of motions for summary judgment as well, which, as you know, can be dispositive. But initially, and for the most of my career, it's been motions directed to pleadings and discovery motions. And however, they can be in almost any type of civil case, which I think makes the civil bench unique in a way, because it could be property. You could go from property to contracts, to torts, to medical negligence, all in a day, all in an hour, for that matter. So it's a well-rounded type of experience that you get on the civil bench, but it takes a lot of research, it takes a lot of reading, and if you're unfamiliar with those areas of the law, it takes more research and reading to familiarize yourself with the area of law first before you can even hope to rule competently on issues.
Well, just to sort of emphasize that point, I know that in any given day, you might have heard motions pertaining to perhaps a foreclosure case where the bank is trying to take someone's home and that person is representing themselves and doesn't have an attorney and is trying to navigate the complexities of foreclosure law, which is sort of nuanced, all the way to multi-million-dollar construction litigation cases, and then maybe, as you referenced, some sort of medical or maybe engineering malpractice that would have some sort of expertise elements that are beyond your knowledge of the law that you would have to learn as well. Is that a fair assessment?
It is a fair assessment, because there have been many days that have been like that, where you have, for construction litigation, you may have 20 attorneys either in the courtroom or appearing on Zoom. And for somebody who's pro se and is representing themselves in a case, whether it be a foreclosure or any other type of case, there's just the pro se party and perhaps an attorney on the other side, or sometimes there's two pro se parties, and then anything in between that. And they can be of any genre of case, as you say, foreclosure, construction litigation, personal injury, motor vehicle negligence, whatever may fit in between there. So it can vary widely in a day. And if you have, say, 9 or 10 hearings in a morning, it just is like going from one to another. And the preparation has always been my key. So
I will echo that. I will tell you that no one has ever accused you in my presence of being unprepared. In fact, having sat in the civil division for 5 years and having reviewed many of your decisions, the arguments from the attorneys always recognized, even if they were challenging your decision, that you were prepared and thorough and knew the law. And that was just, your reputation was really untarnished in those areas. So I hope you feel very good about that. I do want the audience to understand that the civil division in Sarasota disposes of thousands and thousands of cases, every year. I mean, I think the caseloads are, quite robust in this county because of the number of cases that are filed. And so the judges that are sitting in the civil division are tasked with getting through those cases and getting those cases to trial. And so you mentioned discovery, and I know also your work pertained to the pleadings or the legal documents that are the basis for the lawsuit. And so I just want the audience to know that without Magistrate Bailey's work, those cases really couldn't get to trial because there was no way that the civil judges could get to all of those discovery motions and motions directed to the pleading. So, really your work was critical. And you did mention something I wanted to follow up on, and that were Zoom hearings. So, Magistrate Bailey, you were here, at the time when even digital discovery wasn't a big topic, and then you were here at the end when almost everything is digital, and now attorneys are appearing in digital courtrooms. So can you just give us sort of from your viewpoint how that has changed civil litigation in both areas?
In both areas,
in terms of discovery and digital, in the digital realm, and how that's kind of moved from people filing and copying and exchanging papers, all the way to the fact that now they don't even have to come physically into the courtroom. I mean, really, we've come a long way in the last 20 years. So, tell us how that's been for you.
Well, with regard to discovery matters, I think almost everything is done electronically anymore. I think there are some attorneys out there that still copy paper and turn over files to a copy service to have copied, but for the vast majority of cases at this point, it's so much more expedient to do it by electronic means. That's great. I think it leads to better and more timely disclosures in a lot of instances. I know that the Florida civil rules are not quite as strict as the federal rules are. I think they could be stricter, and I think that some of the things that are in the federal rules would help Florida practice, like early meet and confers, and earlier agreements to disclosing, especially in an electronic age as it is now. But I think that the one place that I don't necessarily like it is when I have to do in-camera inspections and I get submissions that are electronic, because after a while your eyes bug out when you've reviewed so many pages that you're looking for either privileged information or something that one side does not want disclosed to the other.
Right.
I prefer paper then, because paper's easier to look at over the long haul.
So let's follow up on that, because that's been a lot of what you've done are these in-camera inspections. And for the audience, an in-camera inspection is something where the magistrate or the judge would look at the documents, usually quite voluminous, to look for particular things that the other side should not be able to see, or perhaps the moving party is trying to prevent the other side from seeing it, and the magistrate needs to decide if that is a legitimate objection. So somebody has to look at it and decide under the law if that information is protected. And so what that means is, and I'm going to ask you about your war stories on this, but what that means is that, the individual tasked with making that ruling has to sit there and look at each thing. And so go ahead and give us some examples of maybe some high volume cases that have been tedious for you in chambers.
I think there are cases that involve trade secrets, commercial litigation, where there are trade secret claims. Those are usually quite involved. And the thing is that for a trade secret claim, you have to have the parties educate you first about the trade secret that is trying to be protected, and what is it, without disclosing too much to the other side, that they are trying to shield and that cannot be put out there for the other side to view. And it's an education process for me first, then I can go and review documents. If I needed a follow-up hearing, I would ask the attorneys, and I would have my assistant Donna call and get them to set a follow-up hearing for more questions that I would have before I could complete something. But then there are things, construction litigation sometimes. I'm thinking there have been zoning cases. There was a zoning case with a development that was happening somewhere along Route 70, near I-75 at one point, and that case had a lot of emails, and there were a lot of claims of privilege as far as attorney-client privilege and work product privilege went, and some of that stuff overlapped at times. That case, I think I reviewed almost 7,000 pages. There were, and at that point, it was still mainly paper. And I had 4 or 5 4-inch binders that came in. And we all know, we're all familiar with the binders.
Oh, yeah, the binders.
The binders that had to be gone through and assessed for privilege.
Yeah.
And that was against a multiple-page privilege log. Everything was Bates stamped, but you're matching page to page, back and forth, to see what's the privilege being claimed, what am I reading, am I reading it in context? That's the other thing, because I think it's important a lot of times in privilege reviews to be reading what you're reading in context and not in isolation. So yeah, those are very detailed. They're very involved. They take a lot of time. And then you have to be very detailed when you write a recommendation as to what you're saying needs to be disclosed or what is not going to be disclosed, making sure you've got all the Bates numbers correct by the time you're at the end. So.
And it's not like you have, as much time as you need, because again, these are pending civil cases that have a clock ticking towards a trial date. And so, the parties are anxiously awaiting for your ruling so they can continue to move forward and make the deadlines they need to make for trial. So it's, and I would just point out too, from my memory of your calendar, you did not necessarily have a lot of time carved out for those sort of reviews, and perhaps we're doing a lot of that on the weekends and nights. Is that right?
I would have to say that yes, there were many times that the reviews and just the job as a whole bled over into the off hours, or what should be your off hours. Right. Because otherwise it's not going to get done in a timely fashion.
Exactly.
And that's been one of my things since the beginning, that if I wanted the bar to trust me, I had to be knowledgeable. I had to show that I had some knowledge of the law. I had to show that I could be relied on to issue timely recommendations, and that I had to issue recommendations that were well written so that you knew what I was telling you. Whether you believed it, liked it, or were going to take exceptions to it or not, you know why I was doing what I was doing.
Right.
And then you could go to the judge if you wanted to take exceptions and say, she's wrong because whatever that case may be.
Right. And it was never that she had not looked at something or examined something. I can tell you that. But well, let's talk about that level of professionalism. I think that you have to be a leader in the courtroom in those areas to get that in return, which you have successfully done. Your expectations, I remember from reading many transcripts and talking to many lawyers in your courtroom, were that the lawyers, when they presented their case, they had to know the law well that they were presenting to you and what they were relying on. They had to have examined the other side's perspective and be able to argue against that, and also to present their arguments in an efficient manner. So what were some of the things that you did, other than just behave that way yourself? What were some of the things you did in your courtroom to make sure that those expectations were met?
I think just continuously during hearings, making sure that they knew what my expectations were. I've always held myself to a high expectation of professionalism, but also a high expectation of being diligent. And when attorneys are coming in front of you and they say things like, well, I thought everybody knew that. Be like, well, you have to know that now. So do you know what authority that you're relying on, or don't? I mean, if you don't, that's okay. You can tell me. I'm okay with it. But just don't say, I thought you knew that. Right. Me, meaning me.
Yeah.
Because I do know that. But, I think it was just reinforcing that each time in court. Just the idea that if you're going to come into court and you're going to put a motion in front of the court, let the motion say something first, because many motions these days don't say anything. They say, I need this, and it's not interposed for purposes of delay, so give it to me. And my first question always is, why do you need it? How come you didn't put that in the motion? Because that would give me the heads up that when I'm reviewing the file, because I review files too beforehand, I might see something and say, oh, okay, that links together now. But I think that is something that gets lost in translation now, and I think that was something that I always, some people would say harped on, was that your motion needs to say something, not just I want something. And just that, I was not afraid to refer attorneys to the standards of professionalism if they needed to review what they needed to do. I found in the last couple of years, I think there's been a little bit of a decline in communication between attorneys. I think COVID had something to do with that. I think that there's been somewhat of a decline in what attorneys attorneys can be snarky, and I've seen a lot of that over the years. But I've always tried to say you need to talk to one another and not just send emails by one another. Pick up the phone and talk to one another once in a while.
Right.
It does a world of good, and you might find that some of these things could be resolved a lot easier if in a 5-minute telephone call than either you or your assistant sending emails to him or her or her assistant that nobody is connecting on all fours.
Yeah,
So-
and I know there's nothing more frustrating than hearing the other side say, "Oh, we don't oppose that," in the middle of a hearing when that hearing could have gone to somebody else. So I appreciate that. But on the note of professionalism, one of the things that you did in your career that I think is significant is that you spearheaded the local professionalism panel here, which was a sort of intermediate level effort from the Florida Bar to address some of the issues that you're talking about. And I know that happened before COVID. So can you tell me about what made you want to do that and how you think that effort had fruit in our circuit?
Okay. Well, it started because I had been on the professionalism committee with Chief Judge Bennett back in, 2009. Dan Danheiser, an attorney in town, had been tasked by the Sarasota County Bar Association to review, and we revised the standards of professionalism in the circuit. And then Chief Judge Owens in 2013, it wasn't so much me spearheading it, it was Chief Judge Owens saying, there's been this decision that's been handed down by the Florida Supreme Court, and we have to have a local professionalism panel. So you were on the professionalism committee, so here it is. And I said, okay, all right. And then just started contacting attorneys that were from Sarasota, from Manatee, trying to put together a committee that we could start to flesh out what should our local professionalism panel look like. We had a very good committee that met several times. We drafted the original AO from 2014 that Judge Owens signed for the original local professionalism panel. And it was just a work in progress. We researched what other circuits were already doing and then kind of crafted our own from a, just looking and saying, well, that looks like a good thing to do, maybe not so much that, so let's go with this. And then crafted the initial administrative order. Some of the people that were on the panel and the committee that put together the first panel agreed to serve as members. You were a member for a while. And it really bore fruit, and Leslie Loftus served as our chair for a long time after the panel was established. And we had, it comes in waves. You get a lot of, at first, we tried to publicize it a lot. We publicized it in the docket, in the inter alia. We put up public notices in the courthouse. And it started to be used, and then it it just seems to come in waxes and wanes for professionalism complaints. But I think it was good, and I think that the way subpanels dealt with attorneys who were referred it was supposed to be a collegial process. It turned out being a collegial process, and the people that I heard from that had been in the process always said that they thought it was good for them because they learned something, and then they learned, hey, you know, I've learned a little bit better of a way to maybe handle the same thing the next time.
Right.
Instead of doing it like I did, I would handle it differently next time. So
yes, it really was a rehabilitative sort of bring attorneys that might be struggling into the fold and help them advance as opposed to anything punitive. I think from my experience, it was very productive. I do want to ask you, I've been dying to ask you this question now that you're allowed to talk about cases, but you know, you have really gotten to rule on some novel issues for the first time. And sometimes some interpretation of a statute will come forward in terms of like insurance litigation or something, and there will be a new statute, and you'll be one of the ones to write the first orders. And then, as we know, those sort of get adopted throughout the state, or somebody takes a different position, and then eventually the judges are presented with these opposing sides to issues with many different rulings across the state. So what can you think of a novel issue that you got to rule on first, and how did it turn out in the end?
Actually, two. One of them was the insurance litigation. And as we know, the insurance litigation is still working its way through the court. With all the legislative enactments over the past couple of years with property insurance. I took a view early on motions to dismiss that these were conditions precedent that needed to be alleged, but you could allege them generally. And the defense bar has kind of taken the position that no, the statute says that if certain things aren't done, you need to dismiss it. And I say, but how do I do that without moving outside the four corners rule? And you want me to look at these other things in order to do that? Well, they're like judges everywhere and other places are doing that. And I said, I know that, but I want to know how they are doing it and how they're moving outside of it. Well, they're reading that they must dismiss. And I said, I understand that, but I don't think I just get to look at anything I want and then just say it's dismissed. And as a magistrate, I've been very careful about that over the years because judges have a little bit more leeway, in my opinion, a little bit more discretion at times to do something. Judges write orders on tear-offs and say it's denied. I've never been able to do that because as a magistrate, you've got to make findings and recommendations. I can't just go, it's denied, go away.
And then it gets reviewed.
So insurance litigation is one, and by taking that position, I think most of the judges, at least in Sarasota, basically took the same position that we weren't going to dismiss on that ground. I said, file a motion for summary judgment. If it's that much of a winner, file your motion for summary judgment. The other one I came across today was after the foreclosure crisis, there were companies that were buying judgments, and then they were suing for deficiencies. And we had one in Sarasota that was brought against a couple who had owned property in Sarasota, but now they lived in Michigan or somewhere else. And they were claiming there was no personal jurisdiction over them to now enforce the judgment against them. And I thought they had their attorneys brought really good arguments to the table. I thought it was very good. I said, yeah, there's no personal jurisdiction. I don't think they appealed that here. But there was a second DCA opinion that came down not long after that said, yeah, there's jurisdiction.
There's jurisdiction. So interesting novel issues. Well, we're getting close to time, and I want to give you the time to have the final word here. I did want to quickly read some comments that were made about you by your colleagues, the judges. Judge Hunter Carroll described you as being smart, extremely diligent and detail-oriented. She's been a pleasure to work with. with, both as an attorney and later as a judge. He thanks you for your decades of service to the people of the 12th Circuit. And Judge Lee Hayworth talked about what a superb writer you are, how you know the arcane details of the discovery rules, and you're respected for your grasp of complex facts in the law, that you handled contentious parties with grace and treated litigants with courtesy, even when sometimes they didn't deserve it. So I echo those comments and just say that you just have been a real pleasure to work with from all of the judges in the 12th Circuit, and we do appreciate your service. But I wanted to give you the time to sort of say your final goodbye to the civil litigants or civil litigation bar that has practiced in front of you for so long.
Okay, thank you. I thank you for the kind remarks from the judges. And it's been my honor to serve with the judges that I've served with on the civil bench over these many years. And to the bar in Sarasota and Manatee, it's been a pleasure to be of service to the bar. I enjoyed getting to know many of the bar members outside of the courtroom through the Inn of Court and through informally in Sarasota County Bar activities and the bench bar conferences. So it's been a pleasure to serve everybody over the last about 18 years. And I wish everyone well. And I'm signing off.
Signing off. Thank you, Magistrate Bailey. That concludes this episode of Law in Sarasota, and we wish Magistrate Deborah Bailey farewell and the best in her retirement. Thank you for watching.
For more than 40 years, the Community Foundation of Sarasota County has partnered with estate planning attorneys and their clients to unlock possibilities for everyone who calls our region home. Our motto, Be the One, reflects our deeply held belief that anyone can be a philanthropist and give back to our community regardless of means. Visit www.cfsarasota.org or call 941-955-3000 for more information.